I think Proposition 8 violates the federal Constitution. I think it violates both equal protection and due process. I would have thought that back when I argued and lost Bowers v. Hardwick. I thought essentially when I filed the ACLU brief in Lawrence v. Texas, in which the court, I'm happy to say, overruled Bowers v. Hardwick, that a denial of equality with respect to marriage for same-sex couples is an irrational insult to a sector of the population and serves no legitimate state purpose. What is interesting to me about Judge Walker's ruling, and I think it's a great testament to the superb lawyering of Ted Olson and David Boies, sort of the dream team, if one could be imagined, from both a legal and a political point of view. What's interesting about the Walker opinion is how systematically and devastatingly it decimates the arguments about a state having a legitimate interest in treating same-sex couples differently. There are 80 elaborate and well-defended findings of fact marching through all of the arguments about how same-sex couples don't make as good parents and all the rest, marching through all of the arguments about how permitting same-sex marriage would somehow indirectly undermine the institution of marriage. To the extent those arguments have empirical or factual substrates, to the extent that they depend on any allegation of fact, they were so thoroughly demolished with, as the judge went out of his way to point out almost with sadness, no real rebuttal by the other side, all of its witnesses having either literally collapsed in the sense that they withdrew or having offered opinion testimony that was non-probative and, in one instance, inadmissible. The whole factual substrate is basically gone. So what that means is that no appellate court is going to find it easy to reverse Judge Walker on the turf where this case was fought out. That is, he didn't purport to apply a heightened standard of review so that the legal question of whether discrimination against people based on sexual orientation is somewhat suspect and should be presumed invalid isn't presented. He said, I'll apply the lowest possible standard, minimum rationality. And applying that standard, he found no factual support for the claims that the state had a legitimate interest here. No support for the claim that this was mere symbolism that didn't hurt anyone. No support for the claim that the state's desire to prop up heterosexual marriage could justify this law. But what that does is leave open the big question not really resolved by Judge Walker. It's the question of whether the state's mere moral opposition to a certain relationship, whether its belief that one kind of relationship is intrinsically more worthy of the state's seal of approval than another, whether that in itself can constitute a per se justification for this form of discrimination. That's not a factual question. It's a purely normative one. It's one on which the record before Judge Walker doesn't really purport to speak. And I think one can, with fair confidence, say that the court will be closely split on that question. There are cases in which a majority has said, actually, if you parse it closely, a plurality, has said that merely moral opposition to a practice or a relationship is sufficient to justify giving it second-class treatment. There are also cases, most recently Lawrence v. Texas, in which the court has said the opposite, has said that moral opposition alone is not enough. Justice Kennedy's opinion in Lawrence v. Texas was written very carefully in such a way that it avoided the question of whether the state, when it doesn't criminalize conduct, but simply refuses to give it its blessing by calling it a marriage, whether in that context the state is subject to the rule of Lawrence v. Texas. In other words, Lawrence v. Texas goes out of its way to say we are not dealing here with a state's mere refusal to give its good housekeeping seal of approval, its imprimatur to a particular kind of relationship. That would be a different case. Curiously, Justice Scalia, dissenting in Lawrence v. Texas, said, on the contrary, if the state cannot use moral arguments to justify outlawing a particular intimate personal practice, then how can it use its moral disapproval to justify treating same-sex marriage less well than opposite-sex marriage? Needless to say, some within the court and some outside the court will quote Scalia back to Scalia, because Justice Scalia's own statements in dissent in Lawrence v. Texas amount to a direct argument that allows one to leap from Lawrence to an affirmance of Vaughn Walker's opinion. But these things are not decided on debaters' points. That is, it's not likely that Justice Scalia will be embarrassed into finding Judge Walker's opinion compelling. It's not likely that Justice Kennedy will be embarrassed into feeling boxed in by those parts of his majority opinion in Lawrence v. Texas that are quite literally indistinguishable from the issues presented in the same-sex marriage case. It's going to be, in essence, a question of first impression for the court. And each justice will have to decide whether his or her understanding of the meaning of the equal protection principle allows a state to say that same-sex couples are not allowed to have the same form of union with the same benefits, intangible as well as tangible, of marriage that opposite-sex couples have. That's not going to turn, I think, on the evidentiary record before Judge Walker. It's going to be a question of the state's power to embody its morality in a rule that prefers certain kinds of relationships to others. And I think that if I had to guess, my own guess is that Justice Kennedy will again be the decisive vote on that question. And if I had to gamble on it, I would gamble that he would vote to uphold Walker. I wouldn't gamble a lot, certainly not my life. And I wouldn't be shocked if he didn't do that, but I would be unsurprised if he did what I think is right in this case as a constitutional matter. I think it helps in making that prediction plausible that the nation has moved dramatically, rapidly on this issue. That is, the degree of outrage that would have greeted the Walker opinion just 2 years ago or 3 years ago just didn't greet it this time. It's really interesting to see that this is not yet a rallying point. It may be that people are waiting in the weeds, but it's not yet a rallying point for conservatives, and the sort of leading political movement on the right at the moment is not so much socially conservative as it is economically conservative. So I think that although the court doesn't measure the election returns or take a public poll, judges are human, and although it's not always popular in confirmation hearings to admit it, they make judgments. That's one reason we call them judges. And in those judgments, they are inescapably affected by what's in the air, what the culture finds acceptable.